Krista Jenkins. I'm Director of Public Mind, and I'm happy to have with us, I'm happy to share with you today the experiences of Jeffrey Deskovic, who is a DNA exoneree, also started the Jeffrey Deskovic Foundation for people who found themselves in a similar situation that he found himself. And without further ado, I'm happy to turn the microphone over to him and allow him to share his experiences with you. Thank you so much for coming.
In 1989, a classmate of mine was found murdered and raped. Peekskill was a small town with a population of approximately 25,000 people. Murders were very rare. So when this murder happened, it understandably it created an atmosphere of fear, rumor, paranoia. Parents were concerned with their own safety as well as the safety of their children. In high school, I was quiet. I was to myself. I didn't participate in very many organized sports. This made me seem strange to some of the kids in the school. In the course of the police investigation, they interviewed many students from the school. Some of those kids told the police that they might want to talk to me because I seemed strange to them. This is what the police said initially attracted them to me. The other factor which they claimed attracted them to me was that they said that I was overly upset at the victim having been murdered. Yet there were mental health facilities set up all throughout the city of Peekskill to help people process what had happened, again keeping in mind that murders were very rare. They reached a point in the police investigation that they asked me to take a lie detector test. I agreed to take the test. And so the next day, rather than report to school, I instead went to the police station. As I just mentioned, it was a school day, which meant neither my mother nor my grandmother with whom I lived realized that anything was wrong, and hence they did not call around looking for me. They drove me to the town of Brewster, which is in Putnam County, whereas I was a native of Peekskill in Westchester County. The significance of my sharing that with you was that that meant I was no longer able to leave on my own. I was instead dependent upon the police. They put me in a small room. I did not have an attorney present. I wasn't given anything to eat the entire time that I was there. The polygraphist himself was actually a Putnam County Sheriff's investigator who was pretending to be a civilian. Aside from him, there were 3 police officers who were there. They played the game known as good cop, bad cop, in which one officer takes on a more aggressive role, whereas his partner pretends to be opposed to what's going on, yet somehow powerless to intervene. The purpose of this technique is that when the person's being questioned becomes fearful, it's only natural that the suspect will look to a friendly face for assistance. Now, before beginning the actual polygraph examination, the polygrapher gave me countless cups of coffee. And the reason why that's important is because the premise of the polygraph is that when a person tells a lie, they'll become nervous. The nervousness will result in an increased pulse rate, and it is the pulse rate which is actually measured by the machine. Other factors which will cause an increased pulse rate, however, would include fear and caffeine. The polygraphist used all types of scare tactics. He invaded my personal space. He raised his voice at me. He kept asking me the same questions over and over again. Over and over again, I told the polygrapher that I was innocent and that I didn't know anything about the crime, yet he persisted in his interrogation, growing more and more ferocious as each hour passed. As each hour passed, so too did my fear increase in proportion to that time. Towards the end of the interrogation, the polygrapher made a statement to me. He said, "What do you mean you didn't do it? You just told me through the test results that you did. We just want you to verbally confirm this." When he said that to me, that really shot my fear through the roof. At that point, who should make his grand appearance other than the officer who was pretending to be my friend? He informed me that the other officers were going to harm me, but that he was holding them off, but could not do so indefinitely. You have to help yourself here, you understand. Considering that I had maintained my innocence for the previous 7.5 hours, it was clear what he meant by that. They wanted me to confess. When it was added that if I did as they wanted, not only would they stop what they were doing, but that I could go home afterwards. Being young, naive, frightened, 16 years old, not thinking about the long-term implications, instead being concerned with my own safety, right then, right there, myself and the police. I took the out which they offered, and I made up a story based upon information which they had given me in the course of their interrogation. By the police officer's own testimony, by the end of the interrogation, I was on the floor in a fetal position, crying uncontrollably. Needless to say, I was arrested. I was charged with murder and rape. Now, before I went to trial, the results of a DNA test came in from the FBI lab, which showed that semen found in the victim did not match. Similarly, hair on the body also didn't match. But rather than acknowledge they made a mistake, they instead continued to prosecute full speed ahead. In order to explain away the exculpatory DNA evidence, the prosecutor elicited fraud on the part of the medical examiner. When an autopsy is done, there are written and audio notes which are taken contemporaneously as the findings are made as a means of ensuring authenticity. It was only 6 months after doing that initial autopsy, and only in response to the DNA not matching me, that suddenly, for the first time, the medical examiner was claiming that the victim, a 15-year-old immigrant from Colombia, in the country for a mere year and a half, living a very sheltered life in which she never went out save accompanied by her parents or her older sister, that he found medical evidence to show that she had been sexually active, which is what opened the door for the prosecutor to argue that it didn't matter whose semen was found inside of her because it could have come from consensual sex she had close enough to her murder and rape so as to explain away the DNA. In order to wrongfully convict me, the prosecutor was willing to trash the reputation of the victim who had already lost her life. Taking it a step further, the prosecutor also mentioned a youth by name that he claimed she had had this encounter with. Yet he never bothered to have a DNA test performed in order to prove that assertion, nor did he even call the other youth as a witness to give verbal testimony to that effect. He simply made the unsupported argument to the jury. At the same time, the public defender that I had was not very good. Here are some of the ways in which he failed me. He never explained to the jury the significance of the DNA not matching me, nor used it to argue that this so-called confession was coerced and false. When it was time for cross-examination of this medical examiner, a key moment in the trial, given the unusually important role in this case that the medical examiner was playing, he stood up in open court and, with a big smile on his face, as if he and the medical examiner were great friends from way back in the day, said to him, "You're going to be pleased to know that I don't have a single question for you." When we hadn't decided if we were going to have a jury trial or a bench trial, which is decided by a judge, my attorney came to me and told me that the judge came to him off the record and told him to pick a jury because he didn't want to be responsible for finding me not guilty. My attorney was supposed to put that extrajudicial statement on the record and ask the judge to recuse himself, because a statement like that shows bias, and also that perhaps the judge was feeling some public pressure, given the fact that every time I made a court appearance, I was on the cover of the local newspapers, and all the articles, save for one, were written from a guilt presumptive-oriented perspective. Every time I wanted to explain to my attorney that I was innocent and what happened in the interrogation room, he was always shutting me up. He never wanted to hear it, just as he very rarely met with me. On one particular occasion that sticks out in my mind, the meeting of which only came about because I insisted on meeting and talking with him, he told me that he didn't care whether I was guilty or innocent. I wanted to testify at the pre-trial hearing, which in legalese is called a Huntley hearing. When confession evidence is going to be used by the prosecution, before a judge is allowed to admit it into evidence, they must first hold a pre-trial hearing in which the judge is supposed to assess whether or not statements that were alleged to be given were given voluntarily and whether the suspect had been read their rights. Now, although testifying to the circumstances of the interrogation truthfully in the main, the cops conveniently left out the illegal portions of the interrogation which they engaged in, namely the threat and the false promise. Given that nobody else was there, I was the only means by which that evidence could make its way onto the record. And so I wanted to testify. Only my attorney wouldn't allow me, telling me that he hadn't decided yet if I was going to testify at the trial or not, and he didn't want to have me on record as to what happened in the interrogation room, for fear that if I decided to take the stand at the trial, that the prosecutor would then use my prior testimony and use it to cross-examine me with, trying to make me out to be a liar even though I was telling the truth. But that really didn't make much sense as I look back on it in hindsight, because had the judge believed my testimony, the statements would have not been admitted into evidence, and therefore, lacking any other evidence on which to proceed, there would have been no trial. Further, if the cross-examination at the pretrial hearing really went badly, there was nothing that mandated that I take the stand, and but for that, the prosecutor wouldn't have been able to use his prior cross-examining of me. So really, that made no sense on the part of my attorney. There was everything to gain and nothing to lose by testifying at the pretrial hearing, except that he didn't allow me to do it. Then when we got to the trial, he wouldn't allow me to testify there either, telling me that it wasn't his job to prove that I was innocent. It was instead the prosecutor's job to prove that I was guilty, and he didn't think the prosecutor had done that. While that might be a legal maxim that you probably might hear in a classroom, that's not how it works in reality. In reality, if you find yourself charged with a crime that you're innocent of, you better do everything in your power to prove that you're innocent, or else you run a risk of possibly being wrongfully convicted. The other reason why he wouldn't allow me to testify is he claimed that his personal one-loss record was significantly better when his clients didn't testify as compared to when they did. Well, that makes sense generically, because most likely the majority of his clients already had pre-existing criminal records, and the only way that would make its way into the courtroom would be if they took the witness stand, at which point the prosecutor would be allowed to ask them questions about their prior crimes. But that really didn't apply to me, because I had no prior record, having never been arrested for so much as a violation. Add it all up together, I guess it's not that surprising that the jury found me guilty. I'll never forget the day when I was found guilty. It seemed to me like I was in some sort of nightmarish alternative reality, because to my way of thinking, at least up until that point in time, only guilty people were convicted. Yet the jury said what they did, and I was taken into custody. On the day of the sentencing, I begged the judge to overturn the verdict because I was innocent, and I referenced the DNA to support my contention. He actually told me on the record, "Maybe you are innocent." Yet that didn't lead him to step up for justice and exercise his discretion by overturning the conviction. Instead, he took the easy, politically expedient way out, which was to sentence me to a term of imprisonment of 15 to life. I would like to share with you a little bit about my prison experience. I still remember the first day. I remember having on handcuffs and having a chain around my waist and having my legs fastened together, as well as being fastened to the legs of the prisoner on the bus next to me. I remember how large the prison walls loomed and how menacing the barbed wire appeared. I don't mind sharing with you that I was really frightened. Yet the wheels of the bus kept turning, bringing me closer and closer to, and eventually into, the prison. As I walked down the cell gallery, there were many prisoners there whose arms were as big as my legs. It didn't take a lot of figuring on my part that if any of them decided to assault me, that considering I was all of 17 years old, weighing about 150 pounds, and these were all fully developed men, many of whom had been working out for years, many of whom were incarcerated rightfully for violent crimes, that if they decided to assault me, that I would not be able to successfully defend myself. I also had the built-in handicap of knowing if they discovered what I was incarcerated for, which was a rape along with that murder, that this would serve as motivation on their part to assault me, because in prison there's a vigilante mentality towards people who've been convicted of sex offenses. The guards themselves were obstacles. To be sure, some were professional and did their job. Yet there were others who brought the problems from their home life into the facility, displacing their aggression onto the prisoners. Then there were other guards who even their peers hated because the manner in which they conducted themselves on a day-to-day basis made it likely that prisoner-to-staff violence could occur. Yet nobody ever bothered to reel them in, not their co-workers, nor the people who supposedly were there to supervise them. Then there were other guards who just wanted to do their 8 hours and go home, and they didn't care what happened while they were there. While that might sound like an ideal attitude that you'd want a guard to have if you had to be incarcerated, it didn't actually work out that way in real life, because it would not be unusual for them to literally look in the opposite direction and walk away, so as to be able to avoid breaking things up and filing paperwork afterwards. There was a system of maintaining order in the prison known as keep lock, which involved a variety of sanctions being imposed on the prisoners if they were found guilty of having broken a prison rule. Some of those sanctions included, but were not limited to, being kept in the cell 23 hours a day. You could take 2 showers one week and 3 the next, rather than being able to shower daily as the rest of the population. They would send you less food. Sometimes the food they'd send you would be 3 or 4 days old. Their idea of complying with the court-mandated 1 hour a day recreation consisted of putting the prisoners in a small caged area with maybe a pull-up bar in it if you were lucky. You would not be able to use the phone to call your friends or family while you were on such status. In the facility in which I spent 13 and a half of the 16 years, Elmira, it was particularly violent there. There were 3 or 4 stabbings or cuttings every day, no shortage of violence that didn't involve weapons, and there was plenty of gang activity. Taken cumulatively, there was a general atmosphere, a general aura of violence, adrenaline, and fear that generally permeated the air. One always had to be on one's toes while in the prison. There were several times in the course of my incarceration that I was assaulted, and one time in which I nearly lost my life. In addition to dealing with that physicality, I was subjected to those sanctions, because in prison, if you were defending yourself, then you were fighting. While I was in prison, I tried to minimize the loss that I was experiencing. I obtained a GED, I got an associate's degree in liberal arts, and I completed an additional year of schooling towards the bachelor's. But then even that silver lining was taken from me, because in 1995 in New York, George Pataki became governor, and he decided it would be a good idea to cut the funding of college education for prisoners, while Senator Helms on the federal level saw to it that prisoners across the country ceased to be eligible for financial aid as well. When that happened, I turned to some of the vocational shops that were available. But although I went to many different shops and amassed many certificates, it looks much better on paper than what it is in reality, for most of the curriculum was obsolete 5 years prior to my ever having stepped foot within the shops. I remember the pay grades that they pay the prisoners for their assignments being something that was either educational, vocational, or something which in one way or another had to do with the everyday running of the prison. I remember they paid 16, 22, 25, 32 cents an hour. In 3 years after that, you could get a raise to 38 cents an hour. There were 4 42-cent an hour slots across the prison, and there was one precious 48-cent an hour pay grade. Out of that money, the prisoners were expected to purchase items for them that the state did not provide to them, such as deodorant, shampoo, pens, paper, postage. And if miraculously there was somehow something left over after that, that was important, because in general there were a lot of problems with the food that the facilities served the prisoners. Some of those issues included the food sometimes being burned, while at other times it wasn't fully cooked. While at still other times there were problems with the portions that were served, while at still others the same items made their way onto the menu in one form or another 4 to 5 times a week. When I first started off my incarceration, my mother made the 4.5-hour journey from Peekskill to Elmira a couple of times a month. But as the long years wore on, and she experienced some financial difficulties, as well as encountered some health issues in terms of her back and her feet, I began to see her less and less until eventually I was lucky if I saw her once every 6 months. I have a brother who's 3.5 years younger than I am, and he too was impacted by my wrongful conviction. The kids on the bus used to try to hit him and stab him with pencils and tell him that his brother was a rapist and call me other nasty names to his face. I guess being unable to get to me, he was the next best thing. In 1996, the prison authorities told me that they received information from the hospital stating that my grandmother was in the hospital and she was extremely sick and she was not going to make it. And so I had a choice. Did I want to wait until she passed away and then go to the funeral service, or did I instead want to see her one last time while she was alive, yet in a coma, and forego the funeral service? Now, at that point, let's examine my circumstances. I already had been incarcerated wrongfully for 6 years. I had lost several times in court. There were many members of my extended family who had not come to see me and who I knew good and well were never going to come and see me so long as I was incarcerated. Considering that I was serving a life sentence, albeit wrongfully, the funeral represented the last clear opportunity that I would have to ever see members of my extended family. So it posed a very difficult decision. I really don't understand why I had to choose. I mean, would it really kill them to allow me to go to both? Yet that wasn't how the system worked, and I had to make a choice. In the end, I decided I would go see my grandmother one last time while she was alive, yet in the coma. I've always gotten motion sickness, and one of the ways you protect yourself from getting sick due to motion sickness is eat before your journey. We set out for Peekskill from Elmira early in the morning prior to the population having been served breakfast. The guards were given funds with which to purchase food items for themselves and for me, but although they bought breakfast items for them, I was merely provided with a cup of coffee. As a result of that, they had to stop the car several times because I was on the verge of vomiting. Yet, because I had very little in my stomach, nothing came out, which I suppose was a good thing, considering that I had on handcuffs and a chain around my waist, and the guards were unwilling to loosen any of those things, even a little bit. So had I vomited and gotten any throw up on my clothes or my face, I would not have been able to wipe it off. Even though there were 2 guards present and both of them had sidearms, and considering the manacles I was wearing, I surely could have posed no threat to them in that state. When we finally reached the hospital parking lot, the guards parked their car as far away from the hospital doors as possible so as to be able to parade me through the parking lot. Again, keeping in mind that I had on handcuffs and a chain around my waist, and my legs were fastened together. I remember there was a nursing attendant on duty, and she got one look at me, and she did a double take, like she couldn't believe the sight of me in front of her. And then there was a child who could have been no more than 4 or 5 years old who was running around playing, and the mother got a look at me and grabbed the child and brought her close to her, as if I was some sort of violent animal that was going to commit a spontaneous act of violence right there on the spot. Needless to say, it was definitely a very humiliating situation. When it was time to go, the guards came in the room and informed me that my hour was up, and I looked up at the clock and I saw that in fact it had only been 45 minutes. But they insisted it had been an hour, and they forced me to leave, again parading me through the hospital corridors and through the parking lot. Unlike the trip down, this time I was given something to eat before the long trip. However, by now, 45 minutes later, with the car having been sitting still, the parking space of which kind of lent itself to the sunlight, like beaming through the windshield, and so by now, the car had become quite hot. Although the guards turned on the air conditioning, none of it reached me, considering that there was plexiglass fully separating the back of the vehicle from the front, and they were unwilling to lower the window even a fraction of an inch. All told, I suffered for about 9 hours in order to visit with my grandmother for less than 1 hour. Towards the end of my sentence minimum, the prison officials told me that if I wanted to have any chance at all at making parole, which was already a slimmer than slim possibility as it was, I would have to take and complete the sex offender training program. The problem with taking that program, however, was that there was an explicit guilt admission requirement in which anybody who was taking the program would have to admit guilt, not simply to the instructor, but also to the other prisoners in the shop. Then, simply saying that one was guilty was not sufficient. They wanted the participants in the program to give details. Then, a verbal rendition was not sufficient. They wanted everything in writing. Failure to complete any one of those components would result in automatic expulsion from that program, with the prisoner being deemed to have refused to have completed the program. Now, at that point, I was looking at parole as a potential means of regaining my freedom, and definitely I wanted to do so before anyone else in my family passed away. So once again, I was in a very difficult position. In the end, after doing a lot of soul searching, I decided I would not take the program. I couldn't bring myself to give details of committing a crime which I knew that I was innocent of. When I went to the parole board, I knew that the parole board was in the habit of rubber stamp denying applications to any applicant who appeared in front of them who had been convicted of a violent crime, regardless of whether they could demonstrate that they had turned their lives around and would, if released, remain at liberty without breaking the law. I knew many people who were working on years 25 and 30 off of a 15-to-life sentence in which they'd go to the parole board, be turned down, ordered to appear in front of them 2 years later, get turned down again, and have that cycle continue in perpetuity. Knowing how that was how they were operating, I tried to protect myself from having that happen to me. I kept repeatedly raising the issue of my innocence and referencing the DNA. But they were unwilling to consider even the mere possibility that I was innocent, not even as a contextual factor for then evaluating the rest of my application. Towards the end of the parole interview, one of the commissioners asked me a question, asking me a question about an aggression replacement training program that I had taken, and I was able to give the answer, demonstrating I had learned the material in the class. That's when a different parole commissioner piped up and said, "Well, that's good, Mr. Deskovic, because you're going to need those skills once you return back to society. Good luck." The procedure is that they don't inform you of their decision right there on the spot, but instead they mail it via institutional mail 3 days later. Considering how the interview ended, I actually walked around the prison for the next 3 days thinking that I had somehow defied the odds and that I would be going home. When I got the decision in the mail, it noted that I had a good educational record, that I had a good disciplinary record, that I had some letters of support, that I even had a prison employee recommending that I be paroled, but that nonetheless I had been convicted of a brutal and senseless crime, and therefore to release me would be to somehow lessen its seriousness. They ordered me to appear in front of them 2 years later. Now, at that point, considering the pattern that they were carrying out that I referenced earlier, it was at that moment that I thought that I was going to die in prison. I would like to share with you how it was that I was cleared. While all that was happening, and a lot more that I'm passing over just for the sake of time, I was simultaneously appealing my case throughout the court system. I went to the appellate division, the first court one must go to, where my primary issues on appeal were my innocence based upon the DNA and that my Fifth Amendment rights had been violated. The court found nothing wrong with the way I had been questioned, and furthermore, they wrote in their opinion that there was overwhelming evidence of guilt, which I still to this day haven't quite figured that one out yet, considering that all the forensics were on my behalf. They ruled against me 5-0. My lawyer then moved to re-argue the case in front of them, arguing that their decision was contrary to the facts and to the law. But the re-argument motion was denied. We then went to the Court of Appeals, New York State's highest court, where the procedure is that you first have to obtain permission from the court to argue your issues before they'll allow you to fully brief your issues and get a decision from the court. The Court of Appeals told me that there was no merit in law to justify reviewing my case, and so therefore they were declining to review it. I then looked to the federal court for relief, filing what's called a petition for writ of habeas corpus, which is when a state prisoner is arguing that his or her conviction was running contrary to the United States Constitution. Again, my primary issues were my innocence as demonstrated by the DNA and my Fifth Amendment rights. Now, at that time, there was confusion in the federal court system because 1 year prior, Congress had passed and President Clinton had signed into law the Anti-Terrorism Effective Death Penalty Act, which, in relevant part, stated that all state prisoners would have 1 year to file in federal court after being denied by their state's highest court. The confusion in the federal system centered around how would this new law apply to cases already in the system, and different jurisdictions were answering the question in a different way. So my attorney called the court clerk and asked for clarification. Would it be enough that my petition simply be postmarked on the due date, or did it instead have to be physically filed and in the building on the due date? The court clerk told my attorney that it would be sufficient if my petition be postmarked. But unfortunately, that information turned out to be false, and as a result of that, my petition arrived 4 days too late. Former Westchester County District Attorney and New York State Attorney General candidate Jeanine Pirro, who has 2 judge shows on television, her office took the position that those 4 days were somehow prejudicial to the people, and therefore the court should simply rule that I was late without even getting to the rest of my issues. And that's exactly the position that the court chose to adopt. That meant that I was time barred, which legally meant that from that point forward, I would no longer be able to argue my issues directly, but instead I was relegated to arguing that the procedural ruling against me was inaccurate in order to have that reversed, to then have my court sent back to the lower federal court to then get an actual ruling on the merits. So I appealed the procedural ruling to the Federal Court of Appeals. And much like the State Court of Appeals, I had to obtain permission from them before they would agree to hear it. I was granted permission, and the following 2 judges would rule on the legal arguments. Those were Judge Rosemary Pooler and future United States Supreme Court Justice Sonia Sotomayor. My lawyer argued that, number 1, this was not a delay caused either by myself or my attorney, but instead by the misinformation by the court clerk. Seems reasonable enough. Secondly, that to uphold a ruling such as that would cause a miscarriage of justice to continue, which in a way tries to backdoor the innocence argument, at least as a contextual argument. And thirdly, that reversing the procedural ruling would open the door to more sophisticated DNA testing of the type which would go on to clear me 7 years later. Once again, the district attorney opposed, and once again, the court sided with the district attorney. My lawyer moved to re-argue the case in front of those same 2 judges, in fact, requesting that all the judges on the circuit hear the case and make a ruling, except that the re-argument motion was denied. That meant we had 1 court left to go to, the United States Supreme Court. While all that was happening, and a lot more that while I was riding the highs and lows that come with losing appeals that the facts and the law suggest you should win, I had to pull myself off the ground from that loud and hard crash and refocus on the next proceeding. Now, I knew that the odds of the U.S. Supreme Court agreeing to hear my case, despite compelling reasons of justice to do so, were slim. Yet, having no other court left to go to, I had no choice but to forge ahead. I was not able to overcome the odds. As expected, the United States Supreme Court declined to give me permission to appeal to them. That marked the end of my appeals and the end of legal representation. That was in 2001. The path, therefore, at that stage to overturning my conviction and thus regaining my freedom would be that I would first have to somehow find an attorney to take my case for free, for neither I nor my family had money with which to hire one. Then hope that we could find an investigator who would work on a similar basis, and then hope that, working in collaboration, the two of them could somehow unearth previously unknown evidence of innocence, without which the court was no longer willing to hear from me. So I began this massive letter writing campaign. I wrote anybody and everybody you could possibly think of who could assist me, either directly or indirectly. I wrote big law firms because I had read that such firms often have a pro bono section in it in which they take cases for free. I very rarely heard back from them. When I would hear back from them, they would tell me that they had no time to take my case for free, although they always made sure that I knew how much money they wanted should I somehow be able to scrape it together. Reading between the lines, what they were really saying was that if I had the money, then they would have the time. Then they would end their letter by saying, "Good luck," as if I'd somehow be all right despite their non-intervention. I wrote reporters, especially those who had written on other wrongful conviction cases and issues, reasoning that their general familiarity with the subject matter would cause them to understand what I was saying in asserting my innocence and referencing the pre-existing DNA exclusion. Maybe I could get their interest and they'd poke around a little bit and write an article or two, as a result of which my case would come to the attention of the necessary legal professionals, as I had read it happen in some other cases. Only I never heard back from any of them. I wrote churches and other faith-based organizations, reasoning that their belief in God, in whatever form or faith that might take, would cause them to be against injustice and by extension in favor of justice, and by extension on my behalf. Perhaps there was a parishioner who was an attorney or an investigator that they could somehow prevail upon to take my case. Or maybe they'd be willing to raise the funds for me so I could hire the necessary legal help. Only I never heard back from any of them. I wrote not-for-profit organizations that do successfully free wrongfully convicted prisoners. The problem I ran into there, however, was that the amount of resources available relative to the amount of cases vying for attention, there was a big disparity, and so in the eyes of the case evaluators, I was unable to beat out the other cases in that cruel competition. In 2005, I had a chance encounter in the mail with an investigator. I was actually writing a book author in care of a publishing company. The author was somebody who had penned her memoirs from when she was a warden of a men's maximum security prison. And so it struck me that she might be somebody who, through her walk of life, either already knew somebody who could possibly help me, or that she would encounter somebody in the future. So I wrote her a letter explaining my circumstances and was asking her to pass on my information. But she never got the letter. Instead, somebody at the publishing company read the letter and instead sent it to this investigator, who wrote me back right away. We brainstormed together. She gave me ideas. She attempted to get people to take my case. One of the ideas she gave me was the winning one. She told me to write the Innocence Project again, which was a not-for-profit organization out of Manhattan that works to free wrongfully convicted prisoners across the country in those instances in which DNA testing can demonstrate innocence and in which no prior testing had been conducted. I say again because I originally wrote them back in 92, 93, when DNA was not as sophisticated as it's come to be now, and so they had never before encountered a case in which there was a DNA exclusion and yet a conviction resulted. Simply conducting testing, comparing the crime scene evidence to my DNA, would merely replicate what was already known, and therefore wouldn't constitute something new. Therefore, they told me, there was nothing they could do. Fast forwarding back to 2005, the investigator told me that with the advent of advancement of DNA testing, the prior denial was irrelevant, and therefore I should write them again. Now, I had been keeping up with the advancement of DNA technology for obvious reasons, but I would not have thought to write them again, thinking that I would get a similar response to what I got the first time around. But I was kind of out of options, and so I wrote them, filled out their questionnaire, and then forgot about it. I continued to look for other means of obtaining representation, none of which were successful. So for the next 6 months, before I heard back from them, unbeknownst to me at the time, but which I now realize, there was a debate within the Innocence Project. For once again, the attorneys in the Innocence Project did not want to go forward with the case because of the pre-existing exclusion. But every time they came to that conclusion, one of the caseworkers, who was not an attorney, would go back to the drawing board and would come up with another theory or another reason with which to represent my case for consideration. At the same time, the investigator was simultaneously lobbying the Innocence Project from outside of the organization. 6 months after filling out the application, seemingly out of the blue, the Innocence Project wrote me back. They informed me that they were going to take my case. By this point, Ms. Pirro had left office, and her successor had been in office for about 40 days at the time at which she was approached. The Innocence Project asked her to voluntarily allow me to have more sophisticated testing, which her predecessor would not. They took the crime scene DNA evidence, which already didn't match, and compared it to the DNA database, which contained profiles of other people who had been either previously incarcerated for violent crimes or who were currently incarcerated for violent crimes. The results matched the actual perpetrator, whose DNA was only in the databank because, left free while I was serving time for his crime, he struck again, killing another woman 3.5 years later, who was a school teacher and mother of 2. Confronted with this evidence, he admitted that he was the person who had committed the crime. He also admitted it to a reporter on video camera. On September 20th, 2006, my conviction was overturned and I was released. I reported back to court November 2nd, 2006, at which point all of the charges against me were dismissed on the grounds of actual innocence. I received an acknowledgement of my innocence from the prosecutor and the judge, though neither of them were their counterparts who originally were involved into my wrongful conviction. At that point, I was free to go to somehow start my life over again with simply the suit that I had on. I would like to share with you a little bit about my life since being exonerated. The world is much different now than when it was when I was originally incarcerated. In terms of technology, let me give some examples. We didn't have internet, cell phone, GPS, or these sophisticated methods of banking. When I walk down cities and towns, although I see similar buildings, structures, and houses, yet others are missing and have been replaced with unfamiliar buildings, houses, and structures. And the people who I once knew that inhabited those cities and towns have long since moved away. Taken together, when I'm in those places, it sometimes has the feeling like I'm in some sort of parallel alternative universe that I don't really quite belong in. Whenever I see my extended family, it's somewhat of an awkward situation because even though I know who they are intellectually and I have memories of them from when I was younger, when you spend significant amounts of time away from people and they don't keep up with the changes that you undergo and you don't keep up with their changes, you become different people, and so there's a big communication gulf. Since being released, I received a scholarship from Mercy College, which I used to complete the bachelor's degree, that 1 year of schooling that I couldn't complete previously. I recently graduated with the master's degree from John Jay College of Criminal Justice. I realized when I was released, when I gave an impromptu, off-the-cuff presentation in front of the media that had gathered at the press conference when I was released, where everything I had ever wanted to say over the course of 16 years but could never quite get anybody to hear, it all came out, one subject matter after another. And it was at that moment that I realized that I didn't necessarily have to become a lawyer in order to become a part of the innocence movement. And so I decided that I wanted to try to take the negative that happened to me and turn it into a positive. And, if I could help prevent this from happening to other people, then I could take some comfort in that silver lining. And so I became an advocate. I gave a lot of presentations across the country. I was a columnist for 5 years at a weekly newspaper where I wrote about wrongful conviction issues. I decided to trade privacy in exchange for a greater level of awareness of issues, hoping that would set the stage for legislative changes to happen to make the system more accurate. And I also learned how to lobby and testify at legislative hearings. A couple of years ago, I finally received some financial compensation, and so I took a significant portion of that and I started an organization called the Jeffrey Deskovic Foundation for Justice, whose purpose is to clear other people who've been wrongfully imprisoned. We have 4 prongs. We raise awareness and we seek legislative changes. Basically more of same, just collaboratively with a support staff. But then we have 2 components which I could never carry out on my own. We have the exonerative component in which we try to clear people, not simply in the DNA cases, which is what most organizations in the field limit themselves to, though that's only around in 5 to 12% of all serious felony cases, but also in the non-DNA cases. And we also have the reintegrative component, which we try to assist people in putting their lives back together again after having been incarcerated wrongfully. In a 1.5 year time, we have the following work product to show. We helped exonerate one person, William Lopez, after 23.5 years. We got another couple of people out via parole while they were asserting their innocence, whereas normally, if you don't express remorse and take responsibility, then it's an almost certain denial. The goal was still to exonerate them, but in the meantime, while an investigation continues, which can take months, if not years, and that's even if it culminates with enough evidence being found to make an innocence claim, at least they've been free in the interim. We created the Thinking Jurors Handbook and made distributions of that outside of state and federal courts. And I helped co-develop the Wrongful Conviction College course syllabus, which I'm happy to say is a staple here now at Fairleigh Dickinson University. I mentioned lobbying both as an individual and as a foundation. So I want to hit those systemic deficiencies real quick so we can all understand that what happened to me is not an aberration. I'll go over the reforms and then we'll open it up for questions. In no particular order, we need to have interrogations to be videotaped from beginning to end, because coerced false confessions have been the cause of wrongful convictions in 25% of the now 311 DNA-proven wrongful convictions. Although adults have been known to give coerced false confessions, false confession experts have identified youth and people with mental health issues as particularly vulnerable populations. Rounding out reforms to prevent wrongful convictions based on coerced false confessions would include false confession expert testimony and a pretrial hearing. Now, false confession experts, they don't testify as to a particular confession that's an issue, but instead they give contextual information as to explain to the jury what are factors that could lead an innocent person to confess, since the average person on the street thinks that, an innocent person would never confess. Then having a pretrial hearing, the focal point of which was accuracy. In other words, whether a confession is deemed to be accurate, as in comparing the statements to known external evidence, rather than just having this voluntariness hearing and a hearing that focuses on Miranda warnings, which has failed us all miserably. We need to have better identification procedures because misidentification has been the cause of wrongful convictions in 75% of the cases. Briefly, some of the areas in this area, some of the prongs of that reform would include having lineups or photo arrays where witnesses would rule people in or out one at a time rather than showing simultaneously, because what happens is that the witness will select the person who most closely resembles their memory, and the actual perpetrator may not necessarily be included in that photo array or lineup. Taking a confidence statement, like on a scale of 1 to 10, how confident are you of your identification? Because in an identification case, the witness's identification is the key issue, and so capturing how confident somebody is at the time that they make an identification, rather than simply eliciting the confidence level that's been achieved by the time all the pretrial prep work has been done, is critical. Telling the witnesses that the actual perpetrator may not necessarily be in that lineup or photo array is important so that an undue level of confidence isn't imparted, while also sharing that if an identification is not made, that the investigation will go on so that nobody feels pressured to make an identification lest the perpetrator escape justice. And finally, videotaping the entire process, which makes it easier to review it for its authenticity, and then the usage of the double-blind method so that the person conducting the lineup or photo array doesn't accidentally or intentionally give inadvertent cues or clues. We need to have safety requirements when it comes to incentivized witnessing, which is when a witness receives an incentive in exchange for testimony. For that's been the cause of wrongful convictions in 15% of the cases. The reforms in this area have to do with the corroboration requirement, which basically, in a nutshell, says that nobody should be convicted solely based upon informant testimony without there being some other external piece of evidence. Then the wearing of a wire that would transmit conversations to a recording device, so that these dubious jailhouse confessions in which people who know each other for a matter of weeks or months, having met in the jail, where they somehow freely talk about having committed serious crimes, that we can be sure that these conversations actually took place rather than being fabricated by desperate prisoners who don't have truthful information to trade on. We need to criminalize clear-cut, intentional prosecutorial misconduct. To me, when a prosecutor engages in conduct such as deliberately withholding exculpatory evidence, working hand in glove with experts, tell me what you want to prove and I'll prove it, rather than ground-level science, suborns perjury, or doesn't correct perjured testimony, and other forms of misconduct, when that's intentional and it results in a wrongful conviction, then to me the prosecutor has in effect pulled off a legal kidnapping under color of law, and therefore there should be a criminal penalty for that. So that right now there's nothing to restrain rogue prosecutors from engaging misconduct. They're not liable criminally, nor can they be sued civilly, thanks to a ruling called Thompson versus Connick, in which the Supreme Court greatly narrowed the door under which you could even sue the office. So with between having prosecutorial immunity and not facing criminal charges, there's nothing to restrain rogue prosecutors, which is why prosecutorial misconduct, through numerous studies that have come out in the last 2 years, has been shown to be rampant and pervasive throughout the justice system, both state and federal. We need to have a standardized evidence preservation system. If you're lucky enough to have been wrongfully convicted in a case that has DNA evidence in it to test, which is only, as I said, 5 to 12%, the first hoop you have to jump through is whether or not the evidence has been lost or destroyed. If either of those things have happened, then the defendant would simply be stuck in prison, unable to prove their innocence. When we think about all these different reforms and the way in which the system is broken, it's pretty clear how a wrongful conviction can happen to anybody. We need a better system of public defense. We should have one statewide system so that there could be oversight and quality control, so that lawyers who have been found to have rendered deficient representation aren't in place to do the same thing. We need to level the playing field. Right now there's an uneven economic and manpower playing field between the prosecutor's office and the public defender. A public defender has to ask a judge to allocate discretionary funding to hire experts and investigators and assist with trial preparation, whereas a prosecutor has an almost unlimited budget. Whereas judges often deny those discretionary requests because they feel pressure to keep the cost of trials down on the county. We need to have equal pay for both sides so that the best legal talent doesn't go to one side or into private practice. And finally, we need to limit the caseload. In many jurisdictions, it's not unusual for one public defender to represent 100 or more clients simultaneously. As college students, imagine if you had to carry 12 classes at the same time. Could you give your best effort each time? Would your grades reflect the best you could do? Of course not. Now imagine multiplying that, and then imagine that somebody's life is riding on it, somebody's freedom, as opposed to just simply a grade. There's ways in which everybody can assist. Learn more about wrongful convictions and share the information with your friends and family. Most of us think that unless you're wealthy or part of some big corporation, that our elected officials, our states and our senators and assembly people are beyond our grasp. But they're not. You can write, email, fax, visit. So long as the politicians think that the status quo is okay, nothing's going to change. It's only when linking passage or non-passage of critical legislation will the status quo change and we finally see some legislative changes. When you think about these easy steps that I've just laid out for us, You think about whether or not you want to act on any of them, whether you want to support financially the work of any of these organizations that work to free the innocent, either at the moment or in future jobs where you find yourselves gainfully employed, at whatever level of employment, you find yourself. You think about this. I had never been arrested for so much as a violation. None of my friends were involved in crime, and I was not a high school dropout. I was actually on my way to school at the time in which I was intercepted initially by the police. It happened to me, and it could happen to you. Thank you.
Well, thank you. On behalf of the Moninger Center and Public Mind, I want to thank Jeff again. We certainly have time for questions, but given the fact that there are so many people in the room, it would be best if we all use the microphone to ask. And so what I would like to do is, if you do have a question, if you could raise your hand, and Shanta will be kind enough to bring the microphone to you. As you'll note, this is being recorded, so it is important that we get the good questions that I'm sure you have today. So who wants to kick it off? Questions? Great. There you go.
Go ahead in the back.
Hi. I just want your thought. How pressured, one, were you to just take a plea? You were obviously facing a major charge. And your thought on how many people where the prosecutor just drums up extra, and the police, extra charges with the goal of just getting a plea?
Yeah, good question. Haven't got that one before, so points for originality. But no, it's true that overcharging is something that prosecutors and police regularly engage in, and the purpose is that so the defendant will get scared about the amount of time that they're facing, and they'll decide to plead guilty in order to try to do damage control. And we see that this not only impacts people who are guilty, but also sometimes innocent people, plead guilty as well. Did that happen to me? I would have to say no. I mean, they did offer me a plea bargain after the trial was finished, but prior to the verdict being rendered. I was offered, my lawyer said that the prosecution offered 5 to 15, and if I wanted him to pursue it, I could get a sentence as low as 1 to 4. But I rejected it because I was innocent. Next question.
Hi. Did they use the polygraph in court? Because according to my learning, that polygraph tests are not submissible in court. So did they just use it to get your conviction or your confession, or did they actually use that in court?
Combination of the two. I mean, they definitely use it as a browbeating psychological tool, but they weren't allowed. As you said, that's not allowed into the courtroom. But what happened was the polygraphist, he backdoored it in, and the judge allowed them to get away with it. I mean, there were times where the polygraphist, swore to its accuracy and, said that he detected that I was lying. So they didn't let him get into his charts and all that, but by making those statements, I mean, it was pretty clear what the results of that were. So they accomplished the same thing. And yes, I do think it was prejudicial.
I thought your suggestions for many reforms were quite interesting, and I hadn't heard many of them before. Is there a place where someone can find them, either on the internet or a paper or organization?
Yeah. Well, within the Innocence movement itself, there's what I'll call, I'll use the term, there's mainstream issues. Those are reforms that everybody agrees on, which are backed by social science. Some of the things which I've referenced, are some of my own ideas based on studies. I mean, criminalizing prosecutorial misconduct. I mean, all the organizations in the field recognize that prosecutorial misconduct is rampant, and they cite it as a factor. They don't take the next logical step and advocate criminalizing it. Why? I think there's an element of political correctness there. I mean, a lot of them depend on cooperation. It's better if you can get the prosecutor to cooperate and allow you to get testing than having to litigate. So I think that comes into play at times. In terms of where you could find more information about the reforms, definitely the Innocence Project's website. They have another place called the National Registry of Exonerations. I have a few websites, including JeffreyDeskovicSpeaks.org. You can just Google my name, and that website will come up. Then there's a lot of, you can even just Google wrongful convictions, and you'll have even scholarly treatises, but they'll be dealing with individual topics rather than it all combined. But definitely the Innocence Project's website, my website, and then lastly, there's 2 critical books which I would suggest for any serious student of the topic, whether a formal student or informal. One of them is the book called Actual Innocence. It's by Barry Scheck, Peter Neufeld, and Jim Dwyer. They reference each systemic deficiency, and then they give you a concrete case where someone was wrongfully convicted by that. It's clear as day how that led to the wrongful conviction, and then you know that the data is valid because the case ultimately culminated in an exoneration proven by DNA. The other book, which is called Convicting the Innocent, which is by Brandon Garrett. Now there, the slight difference between the 2 books is that Mr. Garrett took a more scientific approach where he actually went and read all the transcripts. He applied the scientific method to it rather than just doing, anecdotal relating and that the other book does. But the books are in agreement. But that would be where you could learn more about this stuff.
How did you handle yourself emotionally through the whole process?
Yeah, it was very difficult. I would have to say that isolation, hopelessness, helplessness, frustration, depression, thoughts of suicide, all those things were in my head a lot. I didn't have the luxury of just losing it mentally because I knew that nobody was coming to my rescue. So I was going to have to go out and recruit somebody that I didn't know previously, and so to do that, I would have to keep it together mentally. So that was part of it. Another thing was that I convinced myself that I wasn't serving all that time. I thought I was just doing a year or 2 until the next appeal. Then when my appeals were over, then I looked at parole, and which is why that last year was definitely the most difficult one for me. In the back.
Yeah, I just wondered if there's any estimates in terms of, what percentage of our prison population are wrongfully convicted? And
Yeah. Okay.
Specifically, I'm interested in how many people are freed each year.
Okay, you've got a couple of questions in there. Let me take a stab. All right, let me give you a little bit of context. I'll give you what other entities think, then I'll give you what I think, and I'll give you the reason for why I think what I think, and you be the judge, okay? So there's experts, there's wrongful conviction experts out there, people who study the topic, and they think 1 to 2%. So that's their estimate. A few years ago, DOJ estimated 5%. Let me tell you what I think. Thank you. All right, so here's what goes into my thinking, okay? I think about, I personally did time with 11 people who were exonerated either before I was or after I was in 16 years. So there's that. Then I think about the fact that DNA is only around 5 to 12% of all serious felony cases, and most organizations will only take those type of cases. Therefore, there's a percentage of the innocent population which doesn't have a place to turn to. So if there's nobody working to try to prove them, then the odds are they're going to remain wrongfully convicted, and hence we're not going to discover them. Which kind of leads into my next point. I believe in the iceberg theory. What we see on the top is just a fraction of below. See, all the systemic deficiencies that lead to wrongful convictions in the DNA cases lead that way to in the non-DNA cases, just there's not a way of proving it scientifically. Then when I think about, that every time rogue law enforcement, whether that's on a police officer level, forensic scientist, or any kind of fraud that's been going on for 10 years, 20 years, 30 years, every time that happens, every time a junk science has been unearthed as such, now you're talking about hundreds, if not thousands of cases which were affected, a percentage of which are factually innocent. So given all of that, I think that the percentage is 15 to 20%.
I'm sorry, the second question was, how many people were freed, say, last year through the Innocence Project or other people working on this?
Yeah, I don't remember the exact number. I mean, there were a couple of years where they had banner, I think 3 years ago, it was like a banner year, and they exonerated 27 people, and there were a couple of other years where the numbers were in the low 20s. So, again, I would suggest going to the Innocence Project website, or there's the National Registry of Exonerations is even better, because they're trying to centralize all the wrongful convictions, not simply the DNA, but non-DNA. Last count, there were up to like 1,700 people, and that wasn't even counting places where, like based on these drug cases where there's these excessive sentences and the feds come in, and then before you know it, facing 10, 20 years, everybody is falsely turning in somebody before you know it, the whole town is affected. So they're not even tabulating people like that.
Just a question, the people being exonerated, do they even receive a letter of apology and any type of compensation at all, or assistance?
Yeah, no, they don't receive a letter of apology. I didn't get a letter of apology. I got a verbal apology, but again, it wasn't from any of the people involved in my case. I have to say that my experience in that regard was rare. Normally, there is no apology, and often there's an after comment by the prosecutor. Even after dismissing charges, well, we still think he's guilty. We just can't prove it any longer. So there's that. Then, in terms of compensation, that varies from state to state. There's many states where they don't have compensation at all, while it's still other states, the compensation levels is inadequate. One state, the compensation is a free college education, where another state you can get $5,000 a year up to $25,000, and then other states have other arbitrary limits, and that's the ones that they even have. Ironically, Texas actually has the best compensation package, which is kind of crazy. But even amongst the states that have a good compensation statute, well, again, I have to say, except for Texas, right? You're not given assistance upon immediate release. You have to, like in New York State, for example. I mean, we have a compensation statute on the books. I can file a lawsuit in state court to seek compensation, and I can also file a lawsuit in federal court. And the difference between the two, the legal philosophy with the state one is it seeks to answer the question of what is the state's secondary responsibility and what happened. Whereas in the federal lawsuit, Federal Civil Rights Act, the theory is, now you're pursuing the individual municipalities and actors that, violated your constitutional rights. But even in New York and many other states, there's nothing in place from the time that you're released up until your case is solved. I mean, the average wait is 3 to 7 years. So, I mean, I was home for like 4 or 5 years before I received any compensation, and to me, that's like inflicting an injury on top of an injury. I mean, I was very nearly ended up into a homeless shelter. I was never able to find gainful employment because all the job applicants had experience, which I obviously couldn't match. Oh, okay, good.
Were you ever, during your stay in prison, confronted by gangs or bodily hurt?
Ask your question again, please.
During your prison stay, were you ever confronted by any of the gangs or bodily hurt?
Yeah, I was. Yeah, I didn't have any issues with the gangs, but I was injured. I was assaulted a couple times. One time in which I almost lost my life. I got hit multiple times on the side of my head with a 10-pound weight plate, like you might put on to do flat bench.
Maybe one more question?
I'm a little confused. You stated that your program allowed for parole. So you have some people that's out on parole.
Yeah.
So basically, these people that are out on parole could lose and have to go back and serve time.
Yeah, that's true.
So what do you do, what do your program do to keep these people psychologically sound because of the fact that they could possibly be incarcerated?
Yeah, well, I think, I mean, the same thing that we do for the person that we exonerated. I mean, we maintain regular contact with them, and, we advocate on their behalf when that's necessary. I want to point out, that, again, when people our goal is not to parole people. We do that as a stopgap, humane aspect, because the other organizations don't do that. Okay, so we're trying to, if someone's in prison wrongfully, our goal, look, let's get you out of there as soon as possible, right, in any way that's legal, okay? Then once out, then we'll try to clear you. So, I mean, that's really what we do in that regard. I mean, yes, it's a mental strain, but I mean, some of the people that we've got, like the guy we've exonerated, I mean, he might not be on parole, but up until, I don't know, a couple of days ago, he faced the possibility of going back because the prosecutor was appealing the reversal. So, I mean, that's the best I can really have.